Hello, my name is Mary Laskowski, and I work as the Training and Outreach Coordinator for the Children's Justice Center of King County, part of the King County Prosecuting Attorney's Office. For many people, the criminal justice process can seem overwhelming, but please know that we are here to help. We want to tell you a little bit about how cases move through the court process so you'll know what to expect. This is a general overview, and with that in mind, there may be some differences with your unique experience. In this video, we are going to explain the third phase of the criminal justice process, which is pretrial and trial. After arraignment, the case enters the pretrial phase. During this phase, some people have shared that it feels like not much is happening, but a lot is going on behind the scenes. For example, the prosecuting attorney is looking at the case investigation and any new information. The defense attorney may be doing the exact same thing and having a conversation with the defendant about the case, the evidence that may be brought against them at trial, the punishment linked with the current charge, and what their options may be around a negotiated resolution. You may have heard of a plea bargain, which is what our office refers to as a negotiated resolution. A negotiated resolution is when the prosecuting attorney and the defense attorney talk to find a middle ground called negotiations. During negotiations, both attorneys are in conversation with one another, with input from both the victim and from the defendant about what an outcome for this case could be. This outcome must fall within the sentencing guidelines structure made by the Washington State Legislature. These guidelines are set by the seriousness level of the crime and criminal history of the defendant. Victims and survivors can give input about any negotiated resolution. But sometimes, negotiated resolutions aren't always possible. Both sides may be too far apart in negotiations to find that middle ground that works for all parties involved. The case will then be set for trial. Before trial, a victim or witness may be asked to participate in a defense interview. During a defense interview, the defendant will not be present, but they will be represented by the defense attorney. A victim or witness has the option of having the prosecuting attorney be present for that interview, and in some cases, an advocate. During the pretrial process, omnibus hearings may take place. Omnibus hearings are when the court determines if the case is ready to go to trial. It is very common for a case to have several omnibus hearings, ending with the court setting a new omnibus and trial date. Trials rarely, if ever, happen on the date of the first subpoena that a victim or witness receives for trial. The trial process looks different for every case. In general, a victim or witness will be in contact with the prosecuting attorney or an advocate if one is assigned. Our staff will be in contact with both victims and witnesses to let them know when they need to come to court to testify. At the end of trial, the judge or jury will review all the facts of the case, called deliberation. That deliberation takes as long as is needed, which could be a day or a week. There are a couple of different outcomes after trial. The defendant could be found guilty, which means that the jury believed beyond a reasonable doubt that the crime was committed by that person. Or the jury may be unable to reach a verdict, meaning they did not come to an agreement. Sometimes, this is called a hung jury. If that happens, the prosecutor will figure out the next steps. In the event of a not guilty verdict, the case is considered closed. In the event of a guilty verdict, a sentencing hearing will be scheduled. For more videos and other great content, please visit us at our website.